Assalamu alaikum and welcome to Perspective. We'll be talking about judicial reform which have been on the agenda for the longest time. We don't know when they will finally happen, but there is of course the new Chief Justice, and at this time, as far as the courts are concerned, are we going to see a new direction under his leadership? We are already looking at statements like no adjournments, cases that are coming up. Is there going to be sufficient change within the courts now in terms of how the cases are called up? Is this going to be systemic or more than that? All of these are questions that we are going to be talking about today. I have with me Barrister Safiullah, who is a political analyst and also a lawyer. Thank you so much for being with us today. We also have with us Umar, who's also a lawyer, a legal expert. Thank you for being with us today. Safiullah, we have for time and again talked about the issue of reform. We've also spoken about the fact how there's an inability and an unfortunate failure by successive governments to go in that direction. There has of course been issues like Article 184.3, all of the ambit, all of those things. Are you looking at perhaps, if not a judicial reform which comes through the parliament, perhaps a change which is going to come under the new leadership?
Right. So, Mahrukh, obviously, judges, chief justices themselves have ample powers to decide how things are going to proceed. They can formulate different types of benches. They can form different policies and procedures within the courts. The chief justice is, in fact, a very powerful figure within every court. I have been, of course, very actively following all the developments, all the different chief justices who have come in, and I say this, and it's very unfortunate, but every single chief justice who has ever come in, I've heard their first speech, and the first speech has always been, we are going to carry out judicial reforms, if not by the parliament, then ourselves. And that has always been the case. I specifically remember the kind of things, the kind of very loud claims that were made by, for instance, Saqib Nisar, who said that they're going to completely revolutionize the court systems. However, those were not done. Once again, similar things have been said, maybe not at the inaugural speech, but in various court hearings. Operative dictas have been made in which the Chief Justice has stated that they are looking to conduct reforms, no more judgments will be given. They've also called in senior leadership of the Pakistan Bar Council to discuss how to address this issue. They've even made WhatsApp groups. But if I were to say that, any tangible steps that will have a lasting impact on Pakistan's judicial system have been made, no, not as yet. But I am extremely hopeful that they will be. And honestly, just to end the note here, the only way I will believe that an active step has been made to reform Pakistan's judiciary is by the introduction of technology. You can talk about not giving adjournments, but it's not until it is in a computer that dictates what the next dates are, that dictates how much time someone has, no change will take place.
Let me come back to you. We also have with us Usama Khawar Ghumman, who's a professor at LUMS. He's also an advocate High Court. Thank you for being with us, Usama. I'm going to come to you right after I go to Umar Gillani here. Umar, you heard what Safiullah has been saying as far as the new change is concerned. Are you also hopeful? Do you think in the absence of perhaps a more systemic change, which is what Safiullah is saying, that comes through perhaps proper mechanisms, it's going to be difficult?
So I think that the Chief Justice and the Supreme Court of Pakistan actually have the biggest role to play out of all the actors in the system as far as reducing delays in the delivery of justice is concerned. Judicial delay, especially in the civil justice system, is something which is entirely attributable to the judiciary. And when I say the judiciary, I mean both judges and lawyers.
So you're saying a computer isn't going to cut it until there's an actual change in conduct?
Absolutely. I don't think a computer or even a legislation can solve it. The thing that can solve it is a firm resolve by the judiciary that includes both the judges and the lawyers. And I do think that it is quite inspiring and hopeful that the Chief Justice of the Supreme Court has started taking this issue seriously. I do want to, I would beg to differ with my learned brother, Mr. Ghauri here, on on his observation that every Chief Justice has taken up judicial delay as a priority issue. I think that's rare. If you recall a statement by Chief Justice Jamali, he made a statement before the Parliament that everything is okay. The system is running fine, and we just need to make sure we keep running it. And there was no realization, I think, in previous years that this system has failed to deliver, that people's expectations from the judiciary are rising, and that people have also come to realize that the excuses that the judiciary previously used to make, that no, we can't do anything because the Parliament has to make legislation for procedures, no, we can't do anything because the government isn't assigning enough budgets, those excuses are no longer flying. And the judiciary, I hope, has realized that the buck stops with the judiciary when it comes to judicial delay. It is the job of the judiciary to deliver justice expeditiously and inexpensively. If they're not doing it, they cannot blame anyone else.
Fair enough. Usama, I hope that you've been listening to the diverse opinion of both the lawyers here. Which side would you say your opinion falls on? Because, on the one hand, there is this change that, would be welcome under the new leadership of the Supreme Court. But on the other hand, of course, if it doesn't come through the system, will it follow through? Because there will be invariably a change after a year or so.
Thank you, Mahrukh. So I think I tend to agree more with my learned colleague Umar Gillani sahab, and I would say in a minute why. But I also would like to say that the problem is too big, that it is an entire systems problem rather than judicial problem. But in the immediate context, Gillani sahab is right in saying that lots of delays are due to courts' own lack of will to tackle how lawyers are working or to internal reform. So we have to remember the hardest reforms are internal reforms. It is always very easy to look outward and put a blame on other institutions and segments of society, and we have seen in last 15 years that the judiciary has tried to reform every other institution in the country, have taken suo motu notices, but has rarely followed up on its own internal reforms. And a case, one of the examples being Umar Gillani sahab, if I remember correctly, filed a petition and other few of our other colleagues in Justice Saqib Nisar's era. And they pointed out some very concrete problems that were arising due to judiciary's own conflicting judgments, and over the years the judiciary's scuttling down and reducing the powers of the courts to reduce delays, and the court did not take that matter very seriously. There were few hearings, regular calling of reports, and if I remember correctly, the case was ultimately disposed of. And few of the things that are immediate that the judiciary can address on its own are, for example, non-imposition of costs. So in this country, anyone can file a suit or take someone to Supreme Court several rounds, and no court is going to impose any significant cost for frivolous litigation. In cases where courts do impose costs, there are very insignificant costs. For example, 1,000 rupees cost. If a defendant had spent millions of rupees on frivolous litigations, a couple of thousands cost is which sometime, and that is very rare too, that the courts grant are insignificant. And then there are also the question of conflicting judgments and strikes. So all of these issues over the years, our courts have made the procedure requirements a joke. But apart from these specific, but I think there's also a bigger problem at play, and that is that this system hasn't delivered. This is, and there's lots of post-colonial scholarship on it, that for 150 years, this system, this is what, when white people were here, colonial masters were here, the system wasn't delivering. The system did not deliver after the partition, and this system is not delivering now. So we need a wholesale rethinking of our judicial system, and that would require collaboration between judiciary, political parties, but most importantly, parliament. If we have to reform the system, it had to be led by the political institution, and that is parliament.
Fair enough, but my question is, I'm going to go to Safiullah and come back to you on this, but the question is, in the absence of there being structured reform, for which there are issues, we are looking at the elections, yes, but are we looking at elections at this time that are going to give any party majority? Are we looking at elections that are going to give any party those significant numbers that they would need to perhaps go towards any kind of significant reform? In that kind of an absence of that kind of environment, isn't this the solution?
No. So, Mahrukh, let me be very clear on where I stand on this matter. The parliament can of course come and go. The parliament has made many laws in the past as well. There was for instance in Islamabad there was the Cost of Litigation Act that was imposed but rarely followed through. So even legislations have been made but they have not been implemented by the judiciary. So all of us can agree, at least on the basic idea, that the judiciary is failing to deliver on its own laws, on its own principles, on the laws of Pakistan.
That already exist.
Yeah, that already exist, and that is simply not being carried out. Now, when I said a little while ago that the solution lies in technology, is when I said this, I said it because this is an actionable step that we can take versus something that is intangible like a firm resolve. When I previously stated that every Chief Justice has said this in their inaugural speech, I meant it just to that end, that it was said in their speeches but never implemented. This was never a priority for them. Nobody's ever carried through with actually carrying out any reforms. And so once again we have heard another Chief Justice saying some things, and when a new Chief Justice comes in, there is at least some superficial changes that we do observe for a couple of weeks before things fall back into the pace that they were in. Now the question is we can't obviously expect people to rise up, the lawyers and the judges to rise up one day and suddenly start thinking differently. We have to work with the same material that already exists. How do we bring that change? That's the real question that we need to be asking ourselves. What is that one actionable step that, if taken, will result in the lawyers and the judges actually behaving differently and not resorting back to the same behavior that they were already doing? And that is why I suggest the use of technology. If you take away from the judges the powers to not impose costs, if for instance that is something that the computer just says that okay fine, turns out that this litigation was frivolous, and if it is frivolous then this is the bracket of cost that needs to be imposed, it is going to be a fixed part of every judgment. And of course that will result in several cases of injustice. I'm not suggesting that this is going to be a perfect process, but an overall right step in the direction that we want. If the computer then says a judge cannot grant a date beyond this much, it simply does not allow the fixing of a date beyond that, so that a person with a pen does not have the authority to go beyond a particular date. It's in the computer mainframe, and that is how people will be informed of when the next dates of hearing are. And it's basically the reason why I also talk about the use of technology is because that is literally how every other country that has fixed their judicial process has done so, all across the West. My law firm at the moment does more cases outside of Pakistan than we do within Pakistan. I conclude cases in Germany in a month, and the same case would take 13 years in Pakistan, for the simple reason that we do not have any technological involvement. At every stage we are held hostage by a reader, by a judge, by somebody, by another lawyer who may or may not feel like coming.
Away from
limited authority, of course. We cannot entrust the computers entirely. We are not going all into the age of artificial intelligence, but at least as far as procedures are concerned, which have been defined to a fair degree by the courts, those procedures then need to be implemented, and the only way they can be implemented is if you don't let any individual with a pen cut something out and write something else instead of what is to be done. Just make it hardwired into a computer.
But the problem with that, Umar, is that if you leave it to if that were to happen without there being laws in place or procedures in place, then they would be ultimately at the behest of whoever's heading the institution or a particular court.
I think I tend to believe that it is ultimately the people who run a system who determine how good the system runs. So you give them any kind of machines, computers, artificial intelligence, or just simple registers. If the judiciary is seriously interested in delivering justice in an expeditious manner, they will do it. But if they're not interested in it, they can ruin the most powerful IT tools, and they'll and still just keep doing the same old thing.
Is that interest going to trickle down? You're saying that is it about whoever's at the top? I mean,
I think there is a need for a wider conversation in our society about what the purpose of the state is.
Okay.
If the purpose of the state is principally to deliver justice, which is what is understood in Germany, which is what is understood in many other countries of the world, that the reason why the state exists is actually to help us resolve our disputes in accordance with law. That is the realization which we've never had in Pakistan. Pakistani state has always spoken about, we are here to protect you from evil neighbors, we are here to protect you from poverty, we are here to protect you from all kinds of imaginary things. But the most principal, rudimentary, ancient function of a state, delivering justice and providing law and order,
but the
that has been somewhat
imaginary.
That has been somewhat ignored. I think there is a trade-off between a state which provides focuses on provision of justice and law and order,
but what about
and a
cases
state which focuses on provision of welfare.
But what about cases like, I agree, I think that every judge's job is not to provide that welfare.
The state itself, the judiciary is part of the state. What I'm saying is the Pakistani state has never positioned itself
as a welfare state,
as a state which is going to provide you inexpensive civil justice.
But the question is, like cases, forget about inexpensive justice, for example. One of the two cases that are recently again being talked about are, the Noor Muqaddam case, and I think Sarah Inam's case. Those two cases are cases in point of cases which we haven't seen, are still at the behest of this legal system. So where is the problem there, in your opinion? Without going too much, I don't want to go too much into.
No, the problem is clearly in our criminal justice system, right? So we know for a fact that so these are two cases that are very much on the forefront of the media, that have tremendous public support. We know that every time an adjournment is granted in this case, these things are reported in the newspapers. It causes further public uprising. Recently, a press conference was held by Noor Muqaddam's father and Sarah Inam's father in the Islamabad Press Club, asking as to why such a delay is taking place. And honestly, the judges who are going through those cases, I can't say that they are not delivering justice, because that's literally how the justice system is. Anybody who goes into the court system then suffers for this long before any decision takes place. You cannot, just because Noor Muqaddam's case is more hyped up in the media, you cannot start extra prosecuting one person over all the other accused who are already in the court system. So the problem here is that even a person who is going to get the death penalty goes through this rigmarole for at least a decade before they're convicted. And once again we need to understand why this is happening. Why is it taking a decade just to hang a person if there is absolute and complete evidence as to what that person did? We know for a fact, even if there are confessions in place, why does it take so long? Why did the military suddenly feel like there is a need to have special military courts which go against the principles of international law for speedy justice, so to speak? Why are our courts not, civilian courts, not conducting speedy justice? And that comes down once again to the very structure of these courts. I speak very often about, having been to the courts myself and seen the kind of systems there are within the courts, I feel a lot of pity for the judges when I see that judges have cause lists of over 100 cases. I simply, as a human, cannot go through 100 cases in a day. I don't understand how it is humanly possible to expect that a judge.
So the system being overburdened is just one
tenet of the problem. The other problem, as he said, was also a lack of capacity, a lack of willingness. There is a wide variety of these things.
So why is there this lack of capacity when there is when we say that the legal profession is oversaturated, Umar? When we say that there is
I want to first share my thoughts on why are the courts so overburdened. And I think that is the starting point of the issue. That is where we can actually solve the issue. The courts, the reason why good cases are being delayed is because there are too many false and frivolous cases in the system. The reason why Noor Muqaddam's trial, the trial of the accused person in Noor Muqaddam's case, or the accused person in Sarah Inam's case, the reason why those trials are being delayed is because because there are 5 other completely imaginary, completely false FIRs which have been registered and which are also being tried by the same case, by the same judges. So this is the principal job of the judiciary, to regulate its own jurisdiction. And again, we can't blame anybody except the judiciary itself, which includes lawyers and judges. It's their job to make sure that good cases come and are resolved swiftly and bad cases are not brought. Now, how do you make sure that those 5 other bad cases are not brought? You do it by 3 things. One, you allow the trial courts to exercise the regulatory powers which the procedure already gives them. But there are judgments of the Supreme Court and the High Courts which have actually taken away the trial court's power to regulate its own procedure. So if a person doesn't show up for 3 hearings, the trial judge dismisses the case. But that person then goes to the higher court and gets its case restored. This is just one example of regulatory tools which the trial courts can use and which they can't, which they are not able to use because Supreme Court has laid down bad jurisprudence on those issues. The second thing that the courts can do to regulate their jurisdiction to make sure bad cases don't come as often is to impose costs and in some cases penalty of perjury. So if somebody comes to court and completely lies, once that case is decided, it's not just enough that you let the other party go. You have to make sure that the person who lied on oath in court is made to suffer. Unless there are some
repercussions,
pain, there's some penalty for that, there is a tremendous incentive for people who have the ability to lie with confidence, to institute cases against innocent people, get stay orders against them, drag them into multiple criminal proceedings, and then eventually just walk away.
I don't want to go into the specifics of this, but I think later on I do want to discuss why is it so easy in a system like ours to get stay orders. Because those are things that really need to be thought about.
Absolutely, and Usama was referring to a Supreme Court petition that I filed a few years ago on precisely these issues. So my humble but studied opinion is that getting a stay order should always be easy. But if it is found out that you have obtained a stay order through deceiving the court, through lying, through forging documents, then the penalty should also be exemplary. The solution is not that judges stop giving stay orders. The solution is that they should pursue the case to the end. And if it is found that somebody was abusing the court system, there should be repercussions.
Usama, can you hear me? Usama, can you hear me?
Yes, I can hear you.
Usama, we've been, I hope you've been following the discussion, but also I want to, take it forward a little bit and talk about the role of lawyers. Okay, so we are discussing the judiciary, we are discussing, the invariable consequences of decisions by the judiciary, but the question is also the politicization to a certain extent of the legal fraternity also. We have seen, there is a polarization, one has to agree within the lawyers also, and there is diversification, there is politicization also. So how do we deal with those issues within the legal fraternity?
Thank you. I think this is a very pertinent question, and this has arisen particularly after lawyers' movement, restoration of judiciary back in 2009. I think this is partly, we are victim, and lawyers in a sense are partly a victim of our political conditions ever since independence. So per se, it's a double-edged sword, weapon. On the one hand, lawyers, due to their politicization or due to their adherence to some extent to the Constitution and sort of use that the Constitution, fundamental rights and writ petitions that the Constitution gives them, they have been at the forefront of movements that they have led movements for the restoration of democracy. So since there have been multiple undemocratic interventions in country. But on the other hand, the downside has been that the lawyers, and which is a good politicization, that politicization I support. But then at the same time, the lawyers have, it has come with certain power, and that power has been abused. And that is also a structural problem. The lawyers, if you look at it, the lawyers' profession is almost completely a self-regulated profession. And Mahrukh, this self-regulation mechanism has tremendously failed. If a lawyer were to cheat ordinary litigant or do all the unethical things that are barred by our canon of ethics, there are not going to be any repercussions. And especially after this whole explosion of real estate, the lawyers have been hands in gloves with the real estate mafia. So, and that is precisely because there are no professional repercussions for them, and there's no external check on them. So as I said, it's a complex problem because the lawyers have been able to resist, and we saw recently in times of Qazi Faiz Isa, the lawyers, the entire establishment of the time was out there to get, and some of fellow brother justices as well, but they were able to save Qazi Faiz Isa, and now he's a Chief Justice. But on the other hand, that independence allowed them to do this. But then they also abuse this process, so we have to tread very carefully, considering we have a patchy history of undemocratic forces intervening, trying to undermine democracy here. And if we see at least two of the last two movements, the MRD's movement back in 80s, the lawyers was the first one who led that movement, and subsequently political parties came around. And similarly, the last movement, last two also, when Pervez Musharraf was kicked out, remember it was lawyers. And subsequently, this hybrid regime, once it receded a bit, it was again the lawyers who were at the forefront. But we have to strike a balance, considering our history, our political conditions, and to somehow reform this self-regulatory mechanism, because the litigants, they are also an important stakeholder of this profession, and lawyers cannot continuously abuse this self-regulatory mechanism, because there are serious repercussions, as Umar Gillani has discussed, and by other colleagues. Ghauri Saab.
Safiullah, if you've been listening to what Usama is saying, I think he's gone into some detail about the way that it's. But is it because of the recent political climate, you think? And of course, after the movement, like he said, of the lawyers' movement. But to go back from here is going to be extremely difficult, no?
I think it's going to be impossible, Mahrukh. And once again, we need to look at who we are dealing with. We are, we have, of course, a very proud legal history. Pakistan stands out as one of the very few countries in the region, at least in the region of Asia, that have an independent judiciary. So there are things to be proud of, but at the same time, we need to have a cold, hard look at who we really are. And any lawyer's personal observation, or Gillani's personal observation, my personal observation in this matter would be that there are a lot of fake lawyers amongst us who just go become parts of bar associations and then start working for politicking and not doing any legal work. So the ratio of lawyers to let's say politicians amongst bar associations is actually abysmal. It's very low. And we see a similar trend following through in the judiciary as well. In lower courts, we have seen time and again in exams that judges who cannot pass their exams are still qualified, still put together as judges. When tested, barely any of them can pass the exams of the judiciary itself. So we have a lack of capacity on all sides. We see that people who are not qualified to have even done basic LLB somehow end up getting cards, going to courts, even becoming presidents of their respective associations, at least in smaller areas. We've seen people who are maybe not even qualified to be lawyers, leading lawyers. And this ties in with the overall political system that we have. I see bar communities divided, polarized along the lines of politics. We hear about older times when lawyers themselves were some sort of a community, but increasingly now I see them just divided on the lines of political parties as they stand within Pakistan, and each of them is trying to accomplish a particular political agenda. And this goes all the way up to the Supreme Court, when now we see that whereas we have very high hopes from the Chief Justice, the Chief Justice is extremely controversial because he has been made controversial due to a series of political issues. And we see for the first time in Pakistan's history an extremely fractured Supreme Court. A Supreme Court that is not divided, a Supreme Court that one can at least, through layman's observation, be able to divide into two camps, one camp supporting a particular political ideology, another camp supporting another one. And before this Chief Justice, we know, we have been discussing time and again what the Supreme Court's extremely overtly political agendas were. And that's where the real problem is. Nobody is interested in the problems being faced by the litigants. Everybody is interested in the problems being faced by the political parties. When we discuss law, even on your show, when we come in, how many times do we actually discuss legal issues, and how many times do we actually discuss political issues that are being conflated to be legal issues? And until and unless we start distinguishing between law and whatever the political policies are,
of frivolous litigation, and how, you know, a lot of the political, things in the political realm and the Supreme Court or any court not delving into questions of political questions being one of those.
Of course, we've seen time and again, and this has become very obvious now. Has the Supreme Court behaving almost like a political party in many cases? You know, it's now, we have seen previous Chief Justices as well who seem to be hell bent upon creating their own political vote bank of some sorts. There were many conclusions and expectations that some of these Chief Justices would later get into politics. Thankfully, none have. But
that might still happen.
But, you know, that's really the kind of line that we seem to be headed down on.
But Umar, we've had this discussion, I think, before also on questions of political questions not being the realm of the courts. Frivolous litigation. How do you feel it then?
So I think I want to dwell upon a point which my learned friend Usama Khawar has made. If you want to reform the judicial system, you cannot do it by just reforming the judiciary.
Okay.
In a common law system, you can only reform the judicial system by reforming the legal profession.
Okay.
Because, you know, this is something intrinsic about the common law system which we never dwell upon. Unlike maybe the systems of Qazi justice or even the civil law systems of Europe, in the common law system which the British have and which they gave us and which we are still maintaining, the provision of justice to the ordinary citizen is primarily the job of the lawyers.
Okay.
Because if a person has suffered an injustice, a crime has been committed against him or his daughter or his relatives, or a contract that he signed has been violated, he or she cannot go and walk into the chamber of a judge and say, give me justice.
Okay.
Because that would be considered, you know, illegal, criminal. The seeker of justice can only go to one person, and that's a lawyer. And then it is the duty of that lawyer to make sure that this seeker of justice is able to get some form of justice.
So you're saying that dialogue between the litigant and the judge has to stop, if I'm wrong.
Look, what I'm saying is that in our system of justice, the only person who can get you justice is your lawyer.
Yes.
Which is why reforming the legal profession is such an important tenet of judicial reform.
So what would you do? How would you reform the legal profession? For example, what are the three most important reforms you think should happen?
There should be consequences for a lawyer who lies in court.
Okay.
And those consequences can easily be enforced by the court. So, secondly, we need to look at the Bar Councils and Legal Practitioners Act of 1974 with a fresh look. We have entrusted the regulation of the disciplinary conduct of lawyers entirely in the hands of elected lawyers. We could entrust it to a group of lawyers who are not elected directly but have a tenure. And we could then make sure that the regulatory body of lawyers, the disciplinary board, for instance, has to publish its reports publicly, submit them to the judiciary and the parliament, so that we know that only those lawyers are practicing who are seriously committed to the pursuit of justice.
So do we have any profession at this time, I mean, that is regulated in the manner that you're saying?
The
that
medical profession, for instance,
example,
has recently changed its model of professional regulation.
Okay.
It used to be elected doctors sitting as judges over elected doctors who are accused of medical negligence. Now it's not. Now it's a group of selected doctors who are selected on merit, and also even non-doctors sitting in that tribunal. We could have a system where, through an amendment of the Bar Councils Act, a system where the misconduct of lawyers is judged by a mixed tribunal, which includes a judge, an elected lawyer, an unelected lawyer, and maybe a group of other esteemed professionals. Models of this sort, even the UK, which is the parent body of, which is where we are getting all of our ideas from, has in the last 20 years moved away from the complete self-regulatory model to a mixed model, where the conduct of barristers and solicitors is judged not just by their peers, but by a tribunal which comprises some other people as well, so that the accountability.
But at this time, I want to come back to you. I'm going to go to Usama. Usama, is there at this time any accountability at all as far as the legal profession is concerned?
No, Mahrukh, I don't think there's any accountability, not even semblance of accountability. There's accountability on papers. If someone were not familiar with the actual practice, and they would to examine these laws that these are statutes of the parliament concerning legal profession, and then canons of ethics, which is again a very fat book, then they would say, oh, this is a perfect system, all the mechanisms are in place. The actual problem comes to practice, and that is due to a host of reasons. One, I pointed out the historic role of lawyers. It is not, let me clarify it again, that this is not completely self-imposed collapse, or the lawyers are not only responsible for this collapse and this failure, but there's also another thing which is that elections. There's also some system flaws that are built into the system. The lawyers, the elections are unending. I live in Lahore near these courts, high courts. The election cycle is unending. So I think we should consider, and what is the problem of an unending election cycle? The problem is that those people who are charged to discipline lawyers, they are also candidates, or their groups are candidates, and they have to seek votes from those very people who they have to discipline. And this is a clear conflict of interest. And I think there's, as they say about war, that war is too important a matter to be left to generals. Similarly, I think justice system, lawyering is too important a matter to be left out entirely to judiciary or bar representatives, because the general public has a great stake. We tend to forget, the lawyers and everyone else tend to forget, that the primary purpose of the existence of judiciary and lawyers and all of these professional bodies is to serve the people. The litigants are the primary stakeholders. And we have to emphasize on the primacy of the litigants and have their representatives a say in how the affairs of the bar and judiciary are managed. And I think without that crucial reform, perhaps, and that is where the legislature comes, and that is the reform of Legal Practitioners Act, where reform that how lawyers are disciplined, because the system has clearly failed for the last 50 years at least. And without those very crucial legislative reforms, the system is not going to reform itself because it's a self-reproducing, perpetuating.
However, any Chief Justice of the Supreme Court, how much they want to do it and how sincere they are and the efforts, unless you're saying again, like, Safiullah was saying, it has to be structured. Usama?
Yeah, I agree. I think it has to be a collective effort from all the stakeholders.
Legislative reform, it seems unlikely. Safiullah, even if, even if there is legislative reform, even then, it has to be a combined effort. It has to be that effort by the judiciary to implement those things. Yeah. Because we talk about the oversaturation of laws, for example, in the fact that we have laws in every field, but then again the issue of implementation comes into play.
Is always the problem. So Mahrukh, this is the point that I was making from the get-go. We can sit here and we can expect great things, and it's good to expect good things. It's natural to be optimistic, and we should obviously want that things should change. But if you look at the reality, things are not going to change. Why are they not going to change? Why would lawyers concede to being regulated? Who's going to come and regulate them? Is a political party going to make laws? Are those political parties not influenced by those same lawyers? Are they not the same voter bank? Are the judges not influenced by these lawyers? Are the benches not, are the bars not strong enough to go into protests and strikes and bring those judges to their knees as they have done time and again? So if we talk about a resolve, we then talk about some sort of a dictatorship that needs to be imposed, that would have sweeping changes, not just in lawyers, but across all bodies of professionals across Pakistan. That's not going to happen because, once again, we don't want dictatorship either. We don't want somebody to impose certain laws upon us. And once again, mind you, when it comes to lawyers, I'm firmly of the opinion that the vast majority of the lawyers are not even lawyers. They are just political agents of political parties who are there to serve the interest of their respective political party. They are not actually lawyers who go to the courts and have actual cases on a daily basis. Every single year when I go for for the elections, I see tons of new faces that I've never seen before. And this in itself is a testament to the fact that these are not practicing lawyers, these are not people who actually go to the courts. So to expect that these new faces are going to go back on their own interest and start working towards the interest of litigants is absolutely nonsensical. I once again want to emphasize that the only real step that we can now expect the Chief Justice, and if the Chief Justice is serious about having any realistic changes, I would see the Chief Justice implement a modicum of technology that takes away these powers.
Fair enough.
Unless that happens, we are not going to see any changes.
Your comments before we close, we're also running out of time.
Reformist lawyers, I'm going to take the opportunity of this show to speak to them that if you want to see more justice in this country, no Chief Justice or no Supreme Court judge can do it for you. You have to step up your own game. And I think there are thousands of young, especially enlightened and idealistic lawyers who are out there. They just need to get together and push for reform, push for change within the legal profession. Which is essential for more justice in this country.
Right. Unfortunately, that's all the time that we have. Thank you so much for being with us. Barrister Safiullah Ghauri, thank you for joining us. Umar, Gillani, thank you for being with us today. Usama, Khawar, Ghumman, thank you so much for being with us today. I think we had overall an interesting discussion today on, of course, the changes that the new Chief Justice of the Supreme Court is trying to implement through, for example, less postponement of cases, along with others. But the fact that, of course, it's going to have to come in a more structured way, perhaps it's going to have to come from, from the lawyers, from the legal fraternity. It has to come as a combined effort and perhaps with more technology. All of those things will have to happen along with, of course, legislative reform. Let's hope that we can move towards that because, again, justice system and the courts functioning as was said again, is the cornerstone of any society, any democracy. Thank you so much for joining us today on Perspective.